Dear colleagues, welcome to TRUBOR Online Legal Analytics. I am Maria Barsova, the counsel at TRUBOR Law Firm, and in this video we will briefly look at the current status of IPR protection in the Russian pharmaceutical sector. We will cover three basic topics: compulsory licensing, parallel imports, and patentability criteria. We will also provide some statistics based on Rospatent open data, and we will start with a brief overview of the current regulatory framework for compulsory licensing, taking into account the most recent legislative initiatives and court practice. In Russia, CL may be granted by the court if the following preconditions are met. A patent holder does not use sufficiently his invention within 4 years of granting the patent, and such non-usage, limited usage, results in unavailability of the patented product on the market. And CL is claimed by a person, individual or legal entity who is willing and ready to use the patented invention and with whom the patent holder has refused to enter into a license agreement on the terms and conditions corresponding to the fair commercial practice. CL may be also granted by the court at the claim of the holder of a dependent patent for usage of a dependent invention, if such dependent invention involves an important technical advance of considerable economic significance. Please note, however, that apart from CL, which under Russian law is an obligatory civil law agreement authorized by the court, the Russian Civil Code provides for other mechanisms of IPR restriction, which may have an impact similar to a CL. These are usage of an invention without the patent holder's consent in the interests of state defense and security under a decision of the Russian government, and usage of an invention without the patent holder's consent during any contingencies. The relevant provisions of the Russian Civil Code are indicated on the slide. In general, these provisions correspond to the Paris Convention for the Protection of Industrial Property and TRIPS Agreement. Please note, however, that in 2019, the Federal Anti-Monopoly Service elaborated a draft regulation aimed at expanding the government use of an invention in the pharmaceutical sector. Today, the procedure provided by the draft lacks transparency and contains a number of legal gaps. In May, the relevant draft was passed for regulatory assessment of the Ministry of Economic Development, while the key professional associations submitted their comments and articulated concerns related to this initiative. We note, however, that it is necessary to monitor further developments in this field and wait for the results of the regulatory assessment. Meanwhile, we will look at the current court practice related to CL claims for usage of dependent inventions. A local manufacturer, holder of certain patents for dependent inventions, protecting small modifications of reference medicines, registered a number of follow-on products and their prices prior to expiration of originated patents. Based on mentioned Clause 2 of Article 1362 of the Russian Civil Code, this local manufacturer applied to the court with CL claims. The key court cases are shown on the slide. We note, however, that the status changes are subject to permanent monitoring. Unfortunately, the court practice applies extremely low evidence tests and weak standards of proof, which in 2019 already resulted in CL approval. These issues create significant concerns within the industry and are being discussed with Rospatent and other stakeholders. Apart from this, the parallel imports are still a matter of debate. We remind that parallel imports are based on the trademark rights exhaustion principle and are currently governed at the level of the Eurasian Economic Union. Today, parallel imports are prohibited from non-EU countries based on the regional principle of exhaustion of trademark rights established in the EU Treaty. At the same time, the possibility to authorize parallel imports from outside the EU for certain product groups, including medicines, is actively discussed in the Eurasian Economic Commission starting from 2015. In April 2017, the board of the Eurasian Economic Commission approved the draft protocol on amendments to the EU Treaty. If approved by all EU members, the protocol would grant the Eurasian Interstate Council the authority to authorize the international principle of exhaustion of trademark rights in respect to certain products, which means parallel imports authorized for certain product groups, for instance medicines. However, due to the lack of consensus between the EU members, this could be a long story, and we will close our review with some statistics from Rospatent. According to the last year data of Rospatent, there are currently more than 7,000 patents in the Russian pharmaceutical sector that belong to foreign patent holders, and over 6,000 patents held by local patent holders. Certain market players are concerned that some of such patents are secondary dependent patents which may be used as a basis for CL claims. We were asked several times whether it is possible to annul such patents. In order to answer this question, we also suggest looking at the existing statistic data. In theory, there is a possibility to annul a patent in the Chamber of Patent Disputes existing under the auspices of Rospatent. However, this slide demonstrates that pharmaceutical patent annulment is quite a tough case. At the same time, we note that last year, the Ministry of Economic Development adopted the Order number 527, which introduced certain procedural changes during assessment of patent applications, aimed at avoidance of double patenting of already known compositions and their usage. In theory, it may contribute to restricting the existing unfair market policies, including those associated with CL claims, and may have an impact on the mentioned statistics. And this is all for now. For more details, you may contact me via TRUBOR website or via my professional profiles and social networks. Please stay with us on TRUBOR Online.